Today is the 50th anniversary of Title IX, landmark legislation passed back in 1972 that prohibited sex discrimination in any education program or activity that received federal funds. But now the Biden administration is proposing sweeping changes that some say could pose a threat to women's sports and much more. Joining us now is Sarah Parshall Perry, Senior Legal Fellow at the Edwin Meese Center for Legal and Judicial Studies at the Heritage Foundation. Sarah, welcome back. Great to see you again. Let's talk more about these changes to Title IX that the Department of Education is proposing. How much of an impact do you think this will have?
Significant. In fact, there will be very few educational institutions in the country, either K through 12 or in the context of higher education, that won't be affected, as so many of them accept federal funding. And $1 is sufficient to attach anti-discrimination law through the Department of Education. All schools have to certify compliance with their particular anti-discrimination laws in order to receive their piece of the federal pie. So the biggest change that we've seen is going to have a significant impact, and that's expanding the definition of discrimination based on sex to include discrimination based on sexual orientation, gender identity, and sex characteristics.
Sarah, let me ask you this. If this is enacted, what do you think will happen to women's sports? What will it look like?
Well, we've seen the department say they will engage in separate rulemaking on the sports issue, most likely because that issue does not poll well for the Democrats at all. It's been exceptionally divisive. We've seen Leah Thomas put a very fine point on it in her winning of the women's 500-meter freestyle NCAA championship. So it hasn't polled well. Traditionally, they say they will engage in new rulemaking, but what the language does include, and not one but two spaces, is language that says discrimination that happens on athletic fields or within the context of athletics is also subject to those provisions. So by expanding the definition of sex to include gender identity and pulling in athletic competition, they've already changed the rule whether or not they engage in future rulemaking. It will be catastrophic for women's sports.
And what would happen, say, if a private school, faith-based or otherwise, decided not to abide to these changes?
So Title IX carries by statute a religious exemption, so that is good news, and that it's impossible to change a fundamental federal civil rights law without engaging in rulemaking. There seems at this point to be little to nothing in the new proposed rule about religious exemptions. That is good news for private parochial schools, but many parochial schools get federal funding, whether it's through reduced lunch programs or any other incentive, and that's enough to subject them to Title IX, regardless of whether or not they have a religious exemption. So it does present a pretty chilling picture of the future in education.
And Sarah, what else about these proposed changes do you think is really important for people to know about?
Well, significantly, it institutes sort of a heckler's veto, discrimination based on your unwillingness to adhere to gender identity could subject you to a Title IX sex discrimination complaint. We've seen this already happen in the state of Wisconsin. 3 8th grade boys have been named specifically in a Title IX complaint at the federal level. It also eliminates due process protections during campus investigations on sexual assault and sexual violence that were put in place to protect both the accused and the accuser. Those are eliminated, and it includes conduct that transpires not only off campus, but also after an individual has left the school. So it expands the scope and expands the definition of sex discrimination in a very unfortunate and impactful way.
And Sarah, before I let you go, there's something else I want to touch on. The Supreme Court, as you know, issued a number of rulings today, including one involving concealed carry permits out of the state of New York. I want to get your thoughts on that opinion and also what you think it signals for Second Amendment rights.
Well, it was a tremendous opinion. Justice Thomas wrote the majority with the 3 liberals in what I anticipated to be their particular fiery dissents, but he indicated specifically that these are cases in which we ought not to take constitutional rights lightly, that New York's concealed carry special exception for showing a special and above average reason to be able to receive a concealed carry permit was prohibitive. It was restrictive of a constitutional right guaranteed and enumerated. It is good things not only for Second Amendment advocates, for lawful handgun owners, but also for what we might see in terms of the state of the court for the next few opinions, and make sure that constitutional rights are not infringed.
Well, Sarah, thank you so much for your time today. Great to get your insights.
Thanks for having me.